Good morning, good afternoon, depending on where you are joining us from. We are here today with Tricia Meyer, who is the founder and managing attorney for Meyer Law. We are also joined with Melody Ashby, who's the senior attorney for Meyer Law. Welcome, ladies. How are you?
Very good. Thanks for having us. How are you?
I'm okay. I'm okay. A little bit of a scare this week, but I'm here. I actually wrecked my car, so
Oh,
I'm
no.
uh I'm glad to be here with everybody, but other than that, I'm doing okay. How about you all?
We're okay. We're okay. And we're glad that you're okay.
I know. No car wrecks. I don't want to ever have another car wreck in my future. I'm almost 50 and I've managed to make it my entire life without having a car wreck until now. So
Wow.
um we'll see. I hope I can go another well, if I could go another 50 years, I'll be doing great. So oh, awesome. Well, so Tricia, you are in northern Michigan, is that right?
That's correct.
How's the weather today in northern Michigan?
It's sunny and 60. I'll take it.
I'll take that all day long. Well, it's overcast and 70 in South Carolina. And Melody, you're in Chicago, right?
I am, yes.
How's
And it is sunny and in the 60s. It's actually my ideal weather. So
awesome. Well, y'all are both in the 60s. I don't know. The 70s is okay, but 60s is good. I think it's getting ready to be oppressively hot here in South Carolina. So may have to migrate north where y'all are. Um, well,
except
awesome.
for the humidity, when it gets a little bit hot here, the humidity takes over and then you won't want to be here.
Well, I understand the humidity because we deal with that here. It is atrocious. Well, so I think we are here today to talk about the 5 costly legal mistakes to avoid when growing a business.
That's right. And we are excited to talk about it because there are so many mistakes that you will make when you're running and growing a business, and so many things that you can avoid. So hopefully we'll highlight some things that will be helpful for everybody today.
Excellent. Well, it's always good information when you can get the information from an attorney, such as yourself. And I'm excited to dive in.
All right, awesome. So thanks everybody for joining us today. I will introduce, I'll give you a little bit of background about Melody and I here. I've been a lawyer for 19 years. I founded Meyer Law 13 years ago. Really focused on helping early stage and scaling companies in 6 areas, which I'll talk about in a second here. And then I also recently launched the Clever Baby, which is a baby product company. Melody has been on the team for 16 years, or I'm sorry, rather, she's been a lawyer for 16 years and on the team for 11 years and has helped
Awesome.
thousands of companies. Our clients love Melody so much. We're lucky to have her.
Well, I got to interject and say, I am also a client of Meyer Law, and we have been happy. We have worked with you guys for a couple of years now. And so I've worked with both you, Tricia, as well as Melody, and always a pleasure to do business with you.
Aw, thank you for that feedback. Thank you. We appreciate that. Um, all right, a little bit about Meyer Law. We are a woman-owned law firm. We help startups and scaling companies and large corporations with the legal framework of their business. That essentially means corporate contracts, employment, intellectual property, privacy, and fundraising. We're really entrepreneurial and transparent with billing. I like to say we have a common sense philosophy in that we always provide estimates up front. We also have fixed fee packages, which is really attractive to early stage companies that are watching their costs. And then also offer general counsel fixed fee packages for those companies that need more recurring support every month. We have offices in Chicago, Denver, Los Angeles, and Traverse City. And then we also mentor at incubators and accelerators across the US. And we've also been recognized for several different awards, including on the Law Firm 500 and on the Forbes Next 1000 list.
That's awesome.
Yeah, thanks. And Melody, I don't know if we can actually see your slides or see if you're changing the page on the slides. We're only seeing the first slide there. I don't know if that matters. We can troubleshoot quickly. Maybe we can fix it. Otherwise, it's no biggie.
I don't know. It just says that it's paused, but I didn't do anything to pause it, so don't know.
Okay, technical issues. Gotta love them.
No worries. I did another live stream this week, and the person I was doing the live stream with, he actually got kicked out of a joint room on the stream. So
Oh,
we actually got an office tour. We went with it. It was good.
yeah. Oh my gosh. Oh my gosh. Okay, well, we'll just carry on. And if anybody, has any questions about the information we're providing, feel free to reach out. We'll give our contact information towards the end here. So I'm going to turn it over to Melody now to talk about the costly mistake number 1 that happens often.
Okay, sorry about that. I don't know what's going on. I'm pressing resume share, but it's not resuming. But as Tricia mentioned, costly mistake number 1 is failing to protect your company's intellectual property and confidential information. So whenever you're starting a business, every business should really have a confidentiality agreement or non-disclosure agreement, and just have a situation where you're covering both where both parties will be disclosing confidential information, and another where maybe you're just disclosing confidential information. But the purpose of the agreement is to really ensure that you're defining what is actually going to constitute your confidential information, and then provide restrictions around how the other party may actually use your confidential information. So if you are disclosing any information in your business, you want to make sure that the other party has an actual obligation to keep that information confidential and really only use it for the purposes of which you're authorizing. And so you would want to get an NDA or non-disclosure agreement in place. And within that agreement, you'll have a purpose, and it's really important to define and describe what the purpose of the purpose of why you're sharing the information. So it could be, if it's too broad, unfortunately, what happens is a court could then throw it out. So it could be that you're entering into a potential business partnership, or maybe you're looking to enter into an acquisition and you're sharing information for that purpose. Whatever it is, you want to make sure that it is specified within that agreement. And you also want to define what it is that you're actually sharing. So what is the definition of confidential information? You want to make it broad enough to cover the information that you'll actually be sharing. That could be financial data. It could be commercial data. You might be sharing code. You might be sharing client lists or strategic partnerships. And then you want to ensure that the other party is restricting access to that information to only those individuals or representatives that actually have a need to know that information. You don't want them to be able to just broadly share it with whomever they choose. You'll have parameters with respect to the confidential information, defining what it is, those restrictions around those parties who need to know it. And then also within the confidential information or NDA itself, you want to ensure that there's a specific term, so the amount of time where you're actually sharing information with the other person, but you want to make sure that the obligations of confidentiality actually extend past the term. So for example, perhaps you'll enter into the NDA and for a year, you'll be able to freely exchange information underneath it. But if there's a termination prior to the end of that term, you want to ensure that the confidential information extends 3 years, 5 years. Some clients want it in perpetuity, depending on what information you're actually sharing. But you want to ensure that that obligation continues and lasts longer. Just because the relationship ends doesn't mean that those obligations should end. And then oftentimes we'll receive an NDA for review, and there'll be a requirement where you have to actually mark something as confidential. You want to make sure that you remove that. In practice, what I find is a lot of clients don't actually mark paper documents as confidential, or there's often a requirement that says, oh, we're having a conversation, you have to follow up in writing and in order for that information to be deemed confidential. Well, again, in practice, that often doesn't happen, and you shouldn't lose confidentiality status just because you fail to mark something as confidential or follow up a conversation and say, hey, by the way, the information that I shared with you should be confidential. So that's a requirement that you typically would want to restrict. But in general, when you're talking about intellectual property, if you've developed a unique product, a service, a method, any technology, you want to take the appropriate steps to protect that IP. You know, a lot of times founders, investors, you know, they just want to ensure, again, IP is one of your most valuable assets. And you want to ensure not only that you're not infringing on a third party, but that you're taking the steps internally to ensure that you're protecting it. And so you could protect your protection or your creations in a few different ways. You know, even though we have situations where clients have paid third parties, you want to ensure that those third parties are actually transferring and assigning the IP to your company, and then take the appropriate steps to separately register if you need to. So there's some common protective measures for companies that you can take. You can file what's called a copyright. So copyright's one form of intellectual property protection. It protects original works of authorship. So think software, photography, music, paintings, literature. Generally, copyright holders have the exclusive right to authorize others to do anything with their work. So reproduce it, prepare derivative works, publicly perform it, display the works. Now, the one thing about a copyright is you actually get automatic protection as soon as you create the work. So once it's put in tangible form, you don't necessarily have to take a separate step to register it to claim copyright protection. If you're making the work public, however, it would be good practice and suggested that you actually include a copyright notice, the year that it's created, and contact information, and then also taking the separate step to register with the U.S. Copyright Office. So that's often a question I get from clients is, well, why would I register a copyright if it's protected automatically? And so why you would want to take that separate step is because it enables you to have a remedy to sue in federal court and be eligible for additional statutory damages and attorney's fees, which essentially means more to potentially recover in the event that somebody does use your work without your permission. So that's number one reason. The second reason I would say that you'd want to separately register is that it becomes public record, and then you can actually point to your rights with respect to potential infringers if they are taking advantage. And then if registration actually occurs within 5 years of the date of publication, then it's considered prima facie evidence in the court. So it makes proving your case of actual ownership even stronger. Another way to protect IP would be through a trademark. So a trademark protects kind of the symbolic value of a word, a slogan, a logo. So think about the branding aspect of your business. So a trademark owner uses the branding to identify your goods or services from a third party. And so you would definitely want to take a separate step for purposes of trademark. And so when you're thinking through business names, logos, slogans, you want to first do a clearance. I like to call a common law search and then a federal search as your total clearance. So a common law search would be searching things like Google, all the social media sites, just to see if there's somebody else using similar branding to you. And then a separate search is searching the USPTO's office, the United States Patent Trademark Office, where you could search everything that's pending registration and everything that's currently filed. Now, when the reason why you want to do both searches is because the process of filing a trademark is you would submit the trademark application. Now it takes about 6 months for the USPTO to get an examining attorney to actually review your application. Once they review your application, assuming there's no office actions or where you have to clarify or respond to anything, your trademark would then get published in an official gazette for a 30-day period. At that point in time, anybody has a chance to oppose your registration. So that's why it's a good idea to not only search the federal register where the USPTO registers their marks, because that's what the USPTO looks at, but also the common law search, because what happens with trademark law is the first to be able to, at least in the US, the first to be able to actually claim that they use the mark has common law rights and can prevent somebody else who has used the same branding with similar services that might cause a likelihood of confusion later, and they can oppose your application during that point in time. So that's why it's important to do a broad search to figure out what names or, again, branding you're looking to get protected is actually cleared, because then after you get through the publication part, assuming you don't have opposition, Then it takes about 12 additional weeks after that to actually receive your trademark. So the trademark registration process right now is somewhat lengthy. I would say, 18 months to get approval now just because of the backlog. But again, once you're cleared, you can move forward with the use of your name or logo and obtain rights, but you actually have to use the mark in commerce in order to receive actual registered trademark. So what are the benefits of trademark? Obviously, notifying the public that you claim ownership of that branding or mark. You establish exclusive rights similar to copyright. You strengthen your ability to file legal actions against a third party. And then you could use the registration and further in additional countries should you expand your product or services to those other countries as well. In the meantime, what you can do is you could use the little SM symbol for service marks or TM symbol for products, but that just puts the public on notice that you're claiming superior rights to your name. The R with the circle may only be used when you actually have the federal registration filed. One important thing about trademarks is once you file the mark, you have to continue to use it or you actually lose it. So again, you want to start using the name as soon as possible, and that gives you common law rights. And then once you actually have the mark registered, you have to continue to monitor that mark. You need to also continue to use it. The USPTO does not monitor the mark for you. So if there's somebody that's using a similar name and infringing on your rights, it's up to you to police that mark. So you want to take those additional steps to make sure that you're monitoring that nobody else is infringing on your name once it's filed.
Can I interrupt you real quick? I have a quick question. So your firm actually helped secure the trademark for IT Business Owners Group. I remember doing that a while back with you, but you just said something that I just thought about. I don't take the time to put the trademark in there or the R all the time. But if you said that you will lose it if you don't use it. So
the name, not necessarily
okay.
the symbol. So you have
Okay.
your federal trademark registered name, regardless if you use the little R with the symbol. That just puts people on notice that you actually own the federal trademark. It doesn't mean you absolutely always have to use that. It just puts people on notice. You will own your mark as long as you continue to use it in commerce or in business.
Okay. Perfect. And that would just constitute being on the website or something. If you have a public website, you display it. Okay. All right. Excellent.
And any other questions about trademarks or?
No, hire this firm to take care of it because it was a daunting task and you guys made it super simple. It was very, very much appreciated.
So another way I would say to protect your IP could be through trade secrets. So trade secrets are your secret sauce. So trade secret is just information in a business that you use, and only a select group of individuals within the business technically know that secret sauce. So I think the biggest classic examples of a trade secret would be Coca-Cola's syrup, their recipe, or KFC's spice recipe, where I think they've went into great lengths of creating this vault where only 2 people know the recipe at any given time. Doesn't have to be to that extent, but it could also be cost data. It could be customer preferences. It could be technical drawings. It could be patterns. All of that could be considered your trade secret. So trade secrets can be used in-house, meaning only for the benefit of the owners, or it could be commercialized and licensed out as well. And with respect to trade secrets, and in contrast to copyrights, trademarks, and patents, trade secrets are really kept internal. The way to protect it, you're not necessarily filing anything with the United States government. It could potentially last forever if the business maintains the confidentiality. So that's where NDAs come into play. That's where contracts come into play, license agreements with confidentiality requirements. Courts will assist owners of trade secrets to enforce the rights if you actually use reasonable efforts to actually maintain and protect those trade secrets. So generally, again, you want to limit the access to only those folks who need to know. If you are creating contractual relationships, you want to make sure that Anybody who has access is required to maintain the secrecy of that information. If it's electronically stored, you want to make sure that you've taken steps to protect it, either through passwords or additional, authentication in order to access that information. And then just educational programs to train your staff to the extent that your team has access to that information. You'll want to implement things like best practices related to those trade secrets. And then, of course, an attorney can help any client implement procedures to ensure that you're doing what you need to do to protect those trade secrets. Now, I'll briefly touch on patents. We personally don't handle patents, but we are happy to make recommendations should anybody need it. But patents would be, I guess, the best protection if you have a new product. It doesn't always make sense, I guess, for tech startups, but patent laws have changed. If you're going down that road, I would say speak with a patent attorney early on to make sure that they're doing clearance searches for you, and also just to make sure that your idea or product is actually patentable. A lot of times it is not, depending on whether or not you have a technology process that is new and novel. So take that step. I would do similarly to any type of branding. You want to do clearance. You want to make sure that if something has not already been registered. And even if you have a patent, just think through, you might own a patent, but then you also have to have the means to actually enforce the patent. Similar to trademarks, enforcing patents can potentially be expensive. So, one thing that some early stage companies do is, instead of going for a full-blown patent, they'll file a provisional patent application. And that gives you kind of like a 1-year placeholder to determine whether or not you want to actually proceed and move forward with a full-blown patent. And it's normally a fraction of the cost of actually filing. So that's always an option as well.
Very good.
So I think, I guess key takeaways is just take the steps that you need to take in order to protect your confidential information, as well as your intellectual property. And again, if there are separate filings to take, we typically do recommend to take those separate filings just to legitimize and enforce your ability to protect your IP in the future.
Great advice.
Thanks, Scott. All right, now we're going to move on to the second costly mistake, and that is failing to get contracts in place. I think so often businesses don't realize that they need contracts for everything. All of the different relationships that you're entering into require different types of contracts, and contracts aren't something that's like a one size fits all. What works for one business works for another. Not necessarily, because everybody's business is different. Everybody runs their business in a different way. Everybody's risk tolerance is different, and everybody's relationships are different. And so all of those things really need to be taken into account to ensure that you are protecting your business the way that you should be with contracts. So anytime you are entering into a relationship with another party, you're having them help you with something, just think in the back of your mind, all right, I need a contract. Next is failing. Well, before I move on to the next mistake, let me talk a little bit about the terms that you would want in your contract, one of which is dealing with the intellectual property. So the default under the law is whoever creates it owns it. So if you hire somebody to create something for you, but you don't have a contract that states that they're assigning the rights in the intellectual property that they're creating to you, then they still own that intellectual property. And given that's one of your business's most valuable assets, you want to make sure that that's not happening. You want to make sure that your business owns the intellectual property that's being created. So that's one really important term to have in contracts, because you want to make sure that your company does own the IP that's being created. Another important set of terms would be related to confidentiality. Melody touched on this, so I'm not going to go into great detail, but whenever you're dealing with another party and they're going to have access to your confidential information, it's really important to make sure that you're protecting it. If you disclose it without them having the obligation to protect it, then you lose that status altogether, and that's something that you don't want to do. There's also, terms regarding to payment, fees, payment terms, how long the relationship's going to last, the term of the agreement, how to get out of the relationship, so termination rights and the effect of termination. Those are just some of the provisions that are really important to have in your contracts, along with, of course, description of services, timelines, things like that. Next is, so once people understand, yes, okay, we need contracts for our business, it's really important to make sure that you are structuring the contracts the right way. You want to have as little of friction as possible so you can continue to move your business forward. And oftentimes people don't think of the structure of their contracts in impeding that whole flow of everything that goes on with your business. And so thinking about, the types of customers you're engaging and how you onboard your team members and how you can streamline those things, it's really important. So for instance, a customer contract, your customers might be more traditional, more, like larger corporations that would expect a more traditional contract. In that case, that's what you would want to provide to them, a more traditional contract where you would send it back and forth to negotiate, and then, maybe through a DocuSign or a HelloSign to sign it. There are other instances, though, where you might be able to get away with just sending your customer a link, or maybe they click and agree to your services on your website, in which case you're not having to negotiate terms back and forth. Sometimes you might have a business where you need a hybrid of the two. Maybe you have a link to the main terms and conditions, but more specifics in an order form that they actually sign off on, but reference the link. So being really thoughtful about how you structure your contracts will save you a lot of time and money in the long run and allow you to move your business forward more quickly.
Very good.
Okay, the next mistake, I'll turn it over to Melody.
So the next mistake, or mistake number 4, would be classifying your team inaccurately. So obviously, accurate classification is really important. The Department of Labor and the IRS partner together, essentially to share information to determine entities that are potentially misclassifying their workers. And so what happens is if you misclassify your independent contractor, if you misclassify a contractor when they should have been an employee, then what happens is it can result in fines, penalties. You might have to repay some amount of back taxes. And so to avoid that, you have to ask yourself, is the person that I'm hiring an employee or an independent contractor? And honestly, there's no black and white answer. It's kind of a gray sliding scale, but there are factors that you can consider. If you're hiring a contractor, they're responsible for their own taxes. Now, if you're hiring an employee, it's the employer's liability to pay and withhold federal income tax, Social Security, Medicaid, Medicare, and federal unemployment tax. And so that's why it's important for classification, because as I mentioned, the government wants you on the hook for those things, and they don't want you to be able to skirt the law and not pay those just by saying, oh, well, this person's a contractor. But what you ultimately want to do is think through the actual relationship. How do I know whether or not somebody actually should be a contractor versus an employee? What it comes down to is really the level of control. So behavioral control, as an example, whether or not the business has a right to direct and control how somebody's actually performing. So let's just say that you are hiring us as an attorney. That's a true independent contractor relationship, because although you're hiring us to perform a service for you, you're not telling us how to do our job. We're actually managing, directing how we actually perform those services. You're not giving us those tools to do it. So that would lean definitely as a contractor relationship. But if you are telling somebody how to do their job, if you are providing them the training to do so, if you are controlling how they're working, when they're working, then that's going to lean more towards an employee relationship. Another control factor is looking at the financial control over the relationship. Does the business have a right to control aspects of the job? Like, are you paying them business expenses? Are you providing insurance for them? Those aren't always key factors, but those are factors that lean more towards an employee versus a contractor as well. Or if you're providing equipment for them to perform their job, that could definitely lean more towards an employment relationship. And then just generally the type of relationship, is there a description of the services to be performed? How permanent is the relationship is often a key. Is somebody just coming in to perform project to project things, or is somebody coming in and staying on for 5 years performing the same services? And then how integral are the services to your business? So if it's a situation where the services that the individual is performing is really an integral part of the business, and that's going to lean more towards an employee relationship. And so avoid classification problems, get an agreement in place, define, if it's an employee, you want an employment agreement or offer letter, NDA, whichever, to cover the services and the key aspects of the relationship. If you are hiring a contractor, make sure that it's in writing, that they are in fact a contractor. They're going to be responsible for their own taxes, that you're not responsible for their benefits, things of that nature. And then one small point, I guess, on interns. A lot of folks think that interns are free labor. It is not. You should be paying interns at least minimum wage. If it is an unpaid internship, then you have to meet, I think it's 6 or 7 criteria, and essentially the intern has to be receiving similar training to that of in an educational environment, and you have to meet the criteria, which actually ends up being almost detrimental when you read the factors to the business. So to avoid issues there, just make sure you're at least paying them minimum wage, or ensure that you can meet that certain criteria that the Fair Labor Standard Act has put out in order for you to have an unpaid internship. And just in general, it's just a good idea to document and again, get everything in writing so that it's clear what the classification is to avoid those issues down the line.
Very good information.
Yeah. Okay, great. Yeah, and it's so important when building your team, because oftentimes you don't know how to classify your team. So that's great. All right. Now, lastly, the last costly mistake, number 5, is failing to act in accordance with privacy laws. So privacy laws are changing more now than ever. Nothing's really been done yet at a federal level. And so states are coming down and enacting their own. Hopefully something will be done at the federal level soon, but in the meantime, it's a lot for businesses to kind of keep up with. In addition, if they do any international work, then there's international privacy laws as well to be aware of and make sure that you're acting in accordance with. So generally speaking, you should have an external facing privacy notice that talks about the information that you're collecting and why you're using it and where you're storing it and whom you're sharing it with and all of that. You should also have an internal privacy policy, just, governing how it is, letting your team know how it is that you're using that information and governing like what it is that they can and cannot do with it. And then you should also have a data map put together where it states exactly the type of personal data that you're collecting and whom has access to it within the organization. It's important to really limit access to personal data, both internally and then also sharing with third parties, just to ensure that you are in compliance with the laws. And also, if you are sharing with a third party outside of the organization, you'll also have to enter into certain contractual terms, stating that they'll handle the data in such a certain way and only use it for certain purposes and things like that. Privacy is one of those things that many companies really and honestly aren't following every single thing that they should be doing. They're using kind of common sense practices and things like that, but a lot of the requirements are really stringent, especially on early stage companies. So many of them are just taking the risk, but it's good to at least have a good framework in place where you've got a nice solid data map, you understand the data you're collecting, and you are making sure that if you are sharing it with others, that you have contractual, terms that protect against them doing bad things with that data.
Good points. We don't know what we don't know, correct?
Correct. That is correct. And then that's all that we have for you today. But if you are starting a business, growing a business, and you're not quite sure what to do next, we do offer these roadmaps where you can go to our website, meetmeyerlaw.com, request a roadmap and request one. And then we can provide you kind of with an outlined view or detailed view rather of the things that you should be considering for your business as you grow it.
Awesome. And for anyone, if you do reach out to Meyer Law and engage the firm, please let them know that you saw this live stream and that's where you found out about him, is through IT Business Owners Group. So
Yes.
wonderful. Well, thank you, ladies, so much for your time today. And thank you again for the information. It is a wealth of knowledge. So, and again, I'll say it, you don't know what you don't know. So it's best to hire someone who does know, like Meyer Law. So thank you so much. And I hope y'all enjoy the rest of your day.
Bye.
Thank you for having
Thanks.
us.
Always a
Bye.
pleasure. Bye-bye.